I think good number, and it's now time for us to start. Is it okay?
Yes, ma'am.
So I'll not show any PowerPoint today, but then the overall picture, as we have discussed that in the earlier classes. So this time also I'll just give a overview because not very many sections are there in the syllabus. So without the sections which are before and after what they are given already in the syllabus, will not be able to understand the whole picture of it. So I thought an overview will always be good practice so that you can understand the entire trial proceedings. Now, if you can recollect what I have said in the last class, I said there are different laws for us, and ours is an adversarial system in which both the parties, if suppose there is an issue which is in question, now there will be two parties and both the parties will be heard, and the parties concerned in the issue are called the prosecution on one side, and the defense on the other side. And most of the time we know that the victim is represented by the state. So whenever we see the citations also, we see that so and so versus the state, so and so manne accused name versus the the state ka matlab the victim is represented by the state right from the beginning, that is at the time of giving the report till the end of the trial. The entire cost that is incurred in the process of criminal justice system will be borne by the state only, borne by the state only, because the concept of the criminal proceedings is that it is the harm that is done to the public at large. So that is the concept, and that is the reason why the government takes the onus of representing the victim. Victim need not come into the picture, but at the best what she or he does, the victim does, is go to the nearest police station and then give a complaint. So naturally it's not called as a complaint, they'll report the matter. Now once the report is informed to the nearest police station, then again we have definitions which are given in the syllabus as to cognizable offense and non-cognizable offenses. Now, cognizable and non-cognizable offense classification is entirely based on the concept that police, whether they have some power to arrest somebody or not. Now, if the offense which has been committed will permit the police to go ahead and then arrest somebody even without a warrant, such type of cases are cognizable cases. So the indirect meaning that can be attributed to the cognizable cases is that when serious offense is happening, now police cannot just wait folding their hands that let magistrate give me permission, let me wait till the arrival of that order, only then I'll arrest the accused. So accused will not wait for you, till your arrest, till you make an arrest of that accused. So for that reason, when serious crimes are reported, so there is no need for the police again to wait for an order or wait for a kind of a permission from the magistrate. Instead, what they can do is immediately he has to based on the complaint, he has to go and verify the incident, whether whatever that is been stated in the report, whether it has occurred or somebody is falsely trying to implicate XYZ, what is the status of the case. So for personal verification, it is mandatory on the part of the investigating officer to reach the scene. Now, as I said, every time it may not be so convenient for the investigating officer because the workload of the police station is such that, or maybe some VIP pressing duty may be there, or some other contingent duties may be there. So it is, the law also mandates that it is not compulsory that every time IO only should go, or the SHO leaving the station should go all the way to investigate. So there are provisions, and then provisions say that the subordinate also can be given the task of at least going to the scene of offense and then be there patiently, and then whatever preliminary steps that need to be taken before the arrival of the investigating officer, such kind of arrangements are entrusted to the officer, subordinate, though subordinate to the police officer. So he'll go there, ensure that the proper crime scene management occurs, and then if some accused are suspected, they can be rounded off, they can be taken for interrogation, and then what is the condition of the crime scene, so what precautions he has to take as a police officer to ensure that it is undisturbed and it maintains its integrity. And at the same time, lot of evidences, as we know, are abundant, because as we know, crime scene is the fountain of all the evidences. So once that is spoiled, there is no way that you can again regenerate them. So once you lose them, and there is no way that you reconstruct them or regenerate them. So for that very reason, it is mandatory on the part of every police officer to ensure that the integrity of the crime scene as well as the integrity of the evidences that are present in the crime scene are properly protected. Now this particular step, and of course there are any crime, because it attracts the attention of so many people, including the bystanders, including the witnesses, including the neighbors, and some of the relatives of the victim herself or himself. So they will be there. But it will be the duty of the first responder to see that all unauthorized people from the scene should be evacuated. And if some lives are involved, and the first foremost is, to save lives, that is the first fundamental thing anybody, not only the police, any civilian is supposed to do. Now, that also he has to take care, and some first aid thing has to be given, that also has to be taken care. And if you have to summon the service of other agencies, related agencies like firefighters, depending upon the situation, not in all cases I say, but if the situation warrants, then you should have the access to call other people like firefighters in some case, or bomb disposable squads in some other case, or maybe some cyber experts in some other case. So depending upon the case, and if the situation warrants, definitely he should summon people, dog squad also. So like that, there are some very important agencies whose help we may require, or it may be a terror case altogether, then you may have to take the help of NIA people also. So it again depends, situation warrants. Now after having done all that, now it will be relevant that we should register the case. Now how the registration happens, is there any format that is present? Now there are integrated forms, as we know, that which are being suggested for the sake of uniformity. Now under CRPC 154, if you see, and before I go into sections, my request for all the students, especially when we are dealing law subject, it is mandatory that all of you should have a Bare Act. Bare Act, it will be present in the net also. You can freely download that and keep it by the side, so that whenever I discuss a particular section, it will be very, very relevant, that instead of me reading the entire section, it will be good that you also read it from the net, or read it, keep it as a ready reckoner, so that verbatim I need not need not read the entire section, but instead you can just have a glimpse of that section. So that is the advantage if you have a Bare Act by the side. So this Bare Act, if you can keep section verbatim, if you read, a non-legal person, it will be very difficult, because the construction of the sentences is so complicated that in one go or in one reading nobody can understand that. But then to make things simpler, so what we need to do is we have to dissect the section, understand the meaning of that. That is how we need to do. But anyway, coming to the lecture proper, then I told you that whenever a case which is in which the police have enormous power of arresting somebody without any warrant, because warrant is one thing which will be issued by the court. warrant will be issued by the court. So the cases, I mean, for that, what does it imply? That the magistrate has to issue the warrant. Now, for him to issue that particular warrant is a very lengthy process. It takes time. So if a serious offense is taking place, now law never mandates that even in serious crimes also you just wait for the order of the magistrate. So it doesn't say that. So cognizable cases, that is the reason why they try to divide the cases into cognizable and non-cognizable. So cognizable cases are those cases which do not require any order or permission from the court, and straight away the investigating officer, he can arrest somebody without a warrant. And there is an urgency. Why they are given that power? There is an urgency, and it's a very serious crime, and you cannot have time at your disposal to wait for the order or the permission of the magistrate. Now, all other cases where they require this kind of a warrant and all, I mean, you can still wait. I mean, it's not a very serious offense. You can wait till the order of the magistrate, and leisurely you can go with the proceedings of the investigation. So that's the meaning of that. Now, how do we know whether a particular case is a cognizable offense or non-cognizable offense? Now, for that we need not bother very much. But if there is a Bail Act already with you, you can refer the evidence, the criminal CRPC under schedule, because apart from the sections that are there in the code, you also have attached schedules. When you talk of schedules coming under CRPC, you have first schedule. You have a first schedule in which classification of the offences is given. In which a classification of offences is given. So if you see the columns that are there in that particular schedule 1, it gives offences under the Indian Penal Code. Offences, whatever definition for the offence, punishment for the offence, is a separate code altogether. That is called Indian Penal Code. So Indian Penal Code is a substantive piece of a substantive act which gives you rights, liabilities, duties. So that is, whenever some right is violated, then definitely you will approach the court, and accordingly there will be a procedure, and then some punishment is attached to it, and if the acquisition is proved against the accused, then he will be convicted, otherwise he will be acquitted. So just because there is an acquisition on somebody, it doesn't clearly say whether he in reality, whether he has committed the crime or not, because the person who is a victim always will be in favor of asking a punishment for the, because I have lost these things, and then by some means you please conduct the trial and then ensure that whatever I have lost, you please restore that to me. That will be the plea from the victim side. But on the other hand, accused, if you are not giving him any chance to fight his case or make some arguments against the defense of on his side, now it will not be called a fair play. It will not be fulfilling the principles of natural justice. So for that reason, so whenever a crime is reported, definitely there will be two parties as per the adversarial system, a party representing the victim, most of the time it is the state, and the party which is on the side of the defense. Now both are adverse parties to each other. That is how we need to understand about the procedures. Now coming back to the schedule, I said whenever there is a doubt on the part of the investigating officer whether the offence that is committed is coming under cognizable or non-cognizable, please refer what is known as the first schedule. Now coming to the first schedule, it gives lot of vertical columns, and then the name of each vertical column, if you read, it says section. That means whatever section that we have allotted in the Indian Penal Code, that section will be mentioned, and soon after that we have another column, the name of which is called the offence. That means each section will have a title of the offence or name of that offence. For example, now when I say 109, that is a section under IPC, And what is the name that is given to that offense, which is coming under 199 section? It is called abatement of any offense if the act abated is committed on in consequence and where no express provision is made for its punishment. So it only says this. Now, the next column is whenever the offense is there, the offense will be associated with a kind of a punishment. It can be an imprisonment, it can be a fine, it can be both. So this particular column is going to give you the detail as to the punishment that it can be levied against the offense. Now, the fourth column is our topic now, that is cognizable or non-cognizable. Now, the given offense under this nomenclature coming under section 109, is it a cognizable offense or a non-cognizable offense? So, they are going to tell us clearly, that means law itself, statute itself will divide. On what basis, that's a different story, but then statute gives us the classification as to whether a given crime or whether a given offense is coming under the category of cognizable offense or non-cognizable offense. Why we have to classify that? Depending upon that, police will have some powers. Now, when I say cognizable, immediately we have to understand that these category of crimes are very, very serious crimes in which time is not there, and there is an urgency, and the police officer immediately will be empowered in such cases, even without waiting for the magistrate to give an order, or even without waiting for the permission from the magistrate. He can straight away be into action. So what kind of action he can make? Because why we said serious offense, and in any serious offense there is a great chance that the criminal, when he knows that he has committed a very serious offense, there are chances for him to run away, flee away from the scene, or leave the country and go to some other country, or may become underground. So for these reasons, there is an urgency immediately that you need to apprehend the criminal. So for that reason, they said no problem, no warrant, no permission, no order from the magistrate. You straight away, without warrant also, you can go ahead and then arrest the criminal, is what is the meaning of cognizable offense. And similarly, if you see the fifth column, it says bailable or non-bailable. Bailable or non-bailable. Now, what do we understand by bail? Now, bail is one thing that when somebody is wanted, because after all, when the case comes for a trial, we have to ensure both the accused as well as the witnesses who have seen that thing happening before their eyes, or who are witnesses for the search proceedings, or the witnesses for a seizure procedure, or for a panchanama, or for that matter arrest. So whatever be the activity, whatever be the proceedings, now they will be summoned. The purpose of summon is that on a given date, which is mentioned in the summon under the seal of the proceeding officer, so they will be served. Summon will always be served. So summons will be served to the witnesses as well as the accused. Now the purpose of this bail is so to secure the presence, because there cannot be any trial without the accused or without the witnesses. They are the pivotal people. So without their presence, there cannot be any trial. So for that reason, it is mandatory. So how court is going to implement this? How are they going to say that it is mandatory, that it is compulsory, that you should come definitely and be present on that particular day to depose your evidence? So to make him available on that, and to secure his attendance on that particular day, so summons are given. Now somebody not obeying summon, or somebody you are not very sure that he may leave the country, he may also run away. So to prevent all that, what we are doing is we are arresting that person. Okay? But then you have to, you cannot indiscriminately use this power of arrest. Now there are provisions called bail. Now to ensure that I'll not leave the country, I'll cooperate with the investigation, and whenever summons are there, I'll abide by the summons and all. So just to ensure the court that he will abide by this, now on his personal bond, or with the help of sureties or with some money and all, he is going to give assurance to the court as well as the police that I'll be available for interrogation. In case of police, it will be interrogation, isn't it? So for interrogation purpose or for the purpose of myself be available during the trial and all, I give this assurance. This is surety. I'll give assurance that I'll be present. Now, there are cases, again, depending upon the seriousness of the case or the offense, then there is yet another classification. Like we have classified uncognizable, non-cognizable based on the power of arrest or no arrest. Similarly, there are cases which can be classified into bailable offense and then non-bailable. So the very name bailable means you can give the amount of bail and as a matter of right. I am using the word as a matter of right. Now in all bailable offenses, bail should be given. Bail should be given to the accused as a matter of right. That means he can emphatically ask for the bail because it's a bailable offense. Now bail can be issued both by the police as well as the court. So if the bail is given by the investigating officer, then it is called station bail, because it can be given in the police station also. It is called station bail. In contrast, the court can also give you the bail. Then it is bail again. Now, whether a given case or whether a given offense committed by a particular offender or the accused, does it come under the category of bailable offense or non-bailable offense, is again given in the schedule. Which schedule? Schedule 1. I said Schedule 1 has got lot of columns. In that we have discussed about the section, discussed about the nomenclature of the offense, then we said what is the punishment that is attached with that section, then we also said whether the offense is cognizable or non-cognizable. Then the other column, as I said, the fifth column is bailable, non-bailable. Now, when we say bailable offenses, that means these offenses, bail can be given. Bail can be given, and bail is as a matter of right. That means since the accused can say, see, this is my right and this is a bailable offense, so please grant me bail. So he can demand bail as a matter of right. But in contrast, non-bailable offenses are those offenses in which bail cannot be granted. That means non-availability of the bail. Bail cannot be accepted. But can we say that in all non-bailable offenses, bail at any cost will not be given? It's not like that. It is at the discretion of the court. That means court will apply their judicial mind, and then case to case they will see. And in non-bailable offenses also, if they feel that the facts and circumstances of the case, depending upon the accused nature, gravity of the crime, and also the age of the offender, and then whether he is the single breadwinner of the family or not, or whether he is of a tender age and all, keeping all these factors in mind again. Now, court will have the discretion. It is not as a matter of right that the accused can demand. He can only request, but he cannot demand as a matter of right. But it will be the prerogative of the court. It is completely at the discretion of the judge and the court that they will decide the matter, though it is a non-cognizable offense, where as a matter of fact, as a matter of routine, bail cannot be given as a general rule. But however, it is at the discretion of the court, depending upon the facts and circumstances of the case, whether bail can be given to this man. So some factors I have already told you, that whether the offense is so grave that bail if you give, that he may go outside, get himself released, and then may commit another crime. So depending upon the nature of the crime, depending upon the character of the person, and depending upon what is the status of this person in the society, whether, and in the family, what is his status, is he alone the breadwinner? So like that, there are several factors that will be considered by the court whenever a bail has to be given, and they will completely use their discretion, and then with the reasons written, they will recommend that bail as an exception in this case can be given, though it's a non-bailable kind of an offense. So this is the difference. Say non-bailable, it is the discretion of the court, and in bailable, there is no discretion of the court, it is mandatory, and then the accused as a matter of right can fight for his bail. And there is yet another term, though not defined in the act, it says what you have to understand is there is yet another term called default bail. Default bail. So this is simply that. So for completion of the investigation, there is a stipulated time. The act or the code mandates that there is a stipulated time depending upon the seriousness of the case, ranging from 60 days to 90 days. There is a stipulated time. Now, if for some reasons, without any justification, if the IO in the name of investigation is prolonging the case, and the case is never coming to a logical end, and in absence of any justification, the court, if it feels, yes, there is they are for some reason, for vested reasons, they are not able to complete the investigation, then they said automatically, though it is a non-bailable offense, then the accused can be set free. So there will not be any charges on him now. So he'll be set free. He'll be discharged. So he'll be discharged. So that is called the default bail. So like that, bailable offense, non-bailable offense, then we have the default bail. So other columns are, now once it is bailable, non-bailable, when it is decided, then which court has the power? So we need to understand the hierarchy of the court also, because now simple crimes, petty crimes, and then crimes where punishment is very, very, small punishment is there. So the law mandates that instead of wasting the resources and time of the higher authorities, they can be managed, or the processes can be done at the lower level of magistrate also. So there is a hierarchy of court for that reason. Now there are session courts and courts which are manned by the magistrates of the first order, first class, and then magistrate of the second class, and then chief judicial magistrate, metropolitan magistrate. So under the powers of the magistrates are also accordingly decided. That means what is the pecuniary punishment that a particular magistrate can levy. So depending on that also, we have the hierarchy in the magistrate. And not only the pecuniary thing, then what is the duration? If a serious crime is there, 7 years, 10 years, like murder and all such type of serious crimes, now they can be given to a higher degree of magistracy compared to small petty crimes, which will be the second class or the other. So apart from these magistrates, we also have executive magistrates. Now executive magistrates are those magistrates who do not have normally the power of what you call conducting the trial. They don't conduct any trial, but instead some inquiries and then some preliminary kind of investigations these people can do. Now most of the time the revenue department or the police people, they will be called the executive magistrates. So they will be given the power of investigation, and they can also do some kind of an inquiry, but then they are never in the trial process. Sir, current chudandi. So they can also be given the power of investigation. They are also given the power of inquiry, but the trial will not be their forte. That means they will not be given the power of conducting a trial. So you have to understand that. And the court, what is the court which is giving the conviction. So like that, almost you have 6 columns. In that, the section will be defined, the offense, name of that offense is specified, and then what is the punishment attached to it is also specified. So accordingly, depending upon the offense and depending upon the pecuniary thing, what is the fine that is attached to that particular offense, or some offenses are such that which require both imprisonment as well as fine. In such cases, then it will be decided which court, which magistrate should try this particular offense, and then the sessions courts, though the sessions courts are little higher in the hierarchy, but yet they do not have the original jurisdiction. That means straight away somebody cannot go to the sessions court and then lodge the report can be submitted. The police report will never be submitted. It will be subjected to what is known as scrutiny initially by the magistrate and then magisterial court, and then after ensuring that prima facie there is a case. So this is there is some substance in the case so that it can be processed further, so and can be given to the sessions court. So this process of processing or making some preliminary kind of a trial, it's not actually called a trial, it is called a committal process, committal proceedings. Now this particular thing will be the onus of the magistrate, and once magistrate come to a conclusion after preliminary kind of an inquiry, yes, prima facie there seems to be a case, and this case definitely requires the attention of the sessions. So what they do is they try to make over the case to the sessions, and then once it is in the sessions court, again the process of summons or warrant, depending upon whether a case is summons case or warrant case. So we'll also in the process of learning we'll try to know what a summon case is and what a warrant case is. But time being, you please bear with me that now this is the classification of two bailable offences, non-bailable offences, and then cognizable offences, and then non-cognizable offence. Now in both cognizable and non-cognizable offences also the police will have a role, but then it will be little different when it comes to cognizable cases, and it will be entirely different when it comes to non-cognizable offences. As I said, in cognizable offences, the process of again going to the scene of offence, collecting the evidences, then processing the entire crime scene, and then wherever it has to be sent. For example, in case of rape and all, the victim has to be immediately taken to the doctor even before it becomes an MLC, that is medical legal case. Then it will be mandatory. Now with the Nirbhaya Act and all, we said we need not wait for the registration of an MLC. So immediately if there is a need, if the case warrants, if the situation demands, then it will be obligatory on the part of mandatory on the part of the IO.
In non-bailable offence, the court can decide by studying the case whether bail should be given or not. Accused can only request.
What is
they can't
cognizable?
demand.
What is cognizable?
Cognizable, we consider the crimes that are more serious. We consider such crimes as cognizable crimes. In this case, the police can directly arrest the people without waiting for the warrant from court.
Arrest without warrant. I mean, order permit is otherwise also called as warrant.
Yes.
Warrant of arrest. Then we have also talked about bailable, non-bailable. So what is the distinction between these two?
In bailable, it is a matter of right. It is mandatory for a person to get a bail if it is very, not much serious crime and all. And we also discussed about default bail. If police is not able to prepare charge sheet, the person will get default bail.
No, what is that? What is the meaning of bail? While somebody should give a bail in bailable offences, why should somebody give bail? What is the purpose of taking bail?
So in this, a person is he's signing a bond or paying some amount as an assurance to the court that he or she will be present in court whenever it is needed.
Not only in court, but interrogation and all if he is required. If he is required, he need not be put under arrest. See, arrest ka matlab, you are very sure that he will flee away. But how can you assure? Only if you give an undertaking. It is something like an undertaking. So accused gives an undertaking saying that, so if it is required, if you want, if the police want me for interrogation, for some other information, I am available. I will not run away anywhere. I am very much there in the country, and I'll cooperate with the investigation. So that is the kind of assurance the police or the court can take from him if he can give an undertaking, which and even that also there is pro forma. Not that as he pleases. There is everything. CRPC is so clear that it gives you the pro forma. For arrest, what should be the pro forma? For FIR, what should be the pro forma? For the CD, that is case diary, how it should be written, there is a pro forma. For that, everything there is a pro forma. So for that you need to refer what is known as Schedule 2. So I said there are two schedules in the CRPC. One schedule we have already discussed. In that we said columns are there: section, offense, punishment, cognizable, non-cognizable, bailable, non-bailable, by whom, by which court it can be tried, and also that is one category. That is called Schedule 1. Now when it comes to Schedule 2, again I said there will be pro forma. For all acts, for all the procedures that are mentioned in the CRPC, the Schedule 2 is going to give you the formats. For example, let us say summons to the accused. So summons have to be given to the accused. What do you mean by summon? To ensure his presence in the court, we just make a direction. We try to give, the court will try to give issue, or the police can also issue summons, and summons is a kind of a document in which the details will be there. So the pro forma will be something like that. So whosoever is the name of the person, whereas your attendance is necessary to answer to a charge of the offense, you are hereby required to appear in person or by a pleader, as the case may be, before the magistrate of so and so on so and so date, herein fail not, dated so and so, signature of the presiding officer, seal. So that means there is a form which is called form number 1. So form number 1 is very specific. So what do you understand by that? Schedule 2 is going to give you the formats. Whenever you have to write something, there is a clear-cut pre-printed format for that. So if you have to register a case, there is what is known as first information report from the police point of view. If a summon has to be issued to either accused or the witness, there is a format called form number 1. So they go with their serial number or name of the form. So FIR is one form, CD is one form. Like that, there are formats for each and every activity that is specified at the CRPC. So now we are familiar with now the terms like the FIR. Now FIR, as I said, when the person goes with a problem or with an issue, or when he says that something, my right is violated, or I am being looted, or I am being robbed and all. So you are going to say this near the nearest police station, and then it can be in the form of oral complaint, or it can be in the form of a written. So if a person is literate and all, he will write whatever is there, that he writes in the written form, and then he submits. Now, if somebody is illiterate, then he can give a oral narration of what has happened. Now, that oral thing will be reduced to writing, and when it is given in writing, it will be signed by the IO, and it should also be a thumb impression, because he can't sign and all. A thumb impression of that person can also be, it should be read over to him, and then when he says it's correct, the content of it is correct and all, then the signature of the, in case he is illiterate, the thumb impression. Otherwise, the complaint written can be taken into action, and then there will be what is known as a process called registration of the case. Now, what do you mean by registration? That means your thing is taken into account, your complaint is taken into account, your report is taken into account. So since somebody is coming with a complaint, then that person is called as the complainant. And the complainant will lodge a complaint, and then depending upon whether it is a cognizable case or non-cognizable case, then the police will be into action. And if it is a non-cognizable, if it is a cognizable case, straight away they get powers and all. If it is a non-cognizable case, then what they try to do is they'll direct this person to go to the magistrate. Now magistrate is empowered, the jurisdictional magistrate is empowered to take cognizance of a case. So for some reason the person, private complaint also it is called most of the time. So the person, for some reasons, if the police officer is not entertaining his complaint, he may approach the superior officer. In that case also, if the superior officer is also not entertaining, then the private person always has the option of approaching the court directly. Now once he approaches the magistrate, then it is a non-cognizable case where police have no powers. Policemen, I mean, they have to get the permission of the court or the order of the court. Now it is for the magistrate to decide whether the elements that are there in the complaint, can they make any case or not, non-cognizable case or not. He may inquire himself, or he may entrust the job of investigating the case to the police, return it back to the police with a direction that you should investigate this. Or the third option is that they may, instead of police, they may empower any other person with the powers of investigation except the power of arrest. They may give the all other powers to the person, and then they may designate him as the police officer. But police officers without the power of, because he is a private man, he is not a policeman, so hence he is not given the power of arrest. But except arresting, he will have all the powers. So three options the magistrate will have. So one is, depending upon whether the complaint can make out a case or not, substantial elements are there or not, depending upon that, he may further inquire into the matter. He may further do the inquiry, and then prima facie, if case is there, there is a set of proceeding, again a different proceeding. Or he may think, if it is fit a case, then he may direct this case to the police and saying that you please conduct investigation, and then I am endorsing it, please go ahead with the investigation. He may also give it such type of a direction. Or else he may say, no, I don't want a police to investigate this case, I am entrusting this officer from the court officer, or somebody who is authorized, or some commission I may employ, and then ask that private person again to do the job of a police, because he is a non-police. So hence, except the power of arrest, he will have all other powers. Like the complaint is something different. So it's a kind of an allegation. So when you say a complaint, it's a kind of an allegation against somebody. So that against somebody can be a known person or an unknown person, because every person need not be. Somebody is digging, somebody is doing a construction work. Now all of a sudden from the debris they find out some dead body. Now it is for him to report the matter. Now he goes to the magistrate and then say, this is how what has happened. Now prima facie, you cannot just believe anybody. Now unless the magistrate himself feels that there are three options for him, so he may adopt any of the three. Now for him also to verify, so he has to suppose that particular private complaint, if he says that I also have witnesses, now it will be the duty of the magistrate to examine the witnesses also and examine the complaint, and then if there is something, then decide upon the case. So like that, otherwise what will happen? Unnecessarily, because of some grudge and all, every private person can come and then everybody can say, I suspect so and so person to be the accused. So unnecessary, it will be a kind of a harassment. If each and every case, if the magistrate is going to entertain prima facie, then it will be a kind of a harassment to the accused. So to avoid that, the powers are vested with the magistrate to make some kind of a preliminary inquiry, and on the face of the case, if there is nothing as given in the complaint, then he may not entertain he may drop the complaint also. So that kind of powers are given with the magistrate. Now we have to understand the complaint as an acquisition by X against Y. Now that Y person may be a known person and he may be an unknown person, but the purpose of approaching the magistrate is that he will take an action. So if there is some substance, whether positive or negative or whatever, inaction or action, whatever it is, but he expects the person who is a complainant, the purpose of approaching the magistrate is that he will take some action, a negative action or a positive action, whatever action. Now, an action has to be taken, and then he alleges that there is a commission of an offence. So he wants, the private complainant wants some kind of a enquiry to be done by the magistrate and then do accordingly. So that is private complaint, otherwise called as a complaint, and it is different from report. That you need to understand. Report is something different from the complaint. And what is a report? Report is one, when I said when it is a cognizable offence, now the police will have all powers. Now what do? With the power of investigation, they are going to investigate the entire case, come to some logical conclusions. Now write the CD part 1, that is the case diary part 1, case diary part 2. Then after that they are going to make some entries in the general diary, and after all that, now once the investigation comes to a logical end, they will finally draw what is known as a final report. In some states it's also called the charge sheet. In yet other states it is also called as challan. So whether it is final report or challan or the charge sheet, it will be the final document which most of the time is called the police report. That will also be submitted to the magistrate. Now when I say complaint, it should not be confused with the report. Now what if on investigation, if the investigating officer finds it out as a non-cognizable offence? See, non-cognizable offence where he doesn't have any power. Now if it is a non-cognizable offence, definitely the magistrate has to come in between. Now after some part of investigation, the police officer comes to know the elements of the crime doesn't reveal any occurrence of a cognizable offence, it's a non-cognizable offence. So he feels strongly that it is a case to be handed over to the magistrate. Now in such cases, that police officer himself will become the complainant, and the police report itself will become the complaint. So that is the difference you have to understand. Otherwise, both the police reports at the end of the investigation and the complaint both reach the magistrate. So in one case, based on the police report, the proceedings will go, and in case of complaint, so depending upon the 3 options that he has got, so accordingly that will also simultaneously go. Now once the police report is made out, now as it is called before the charge sheet or the final report is framed. Now as I said, whatever investigation that is happening, because in the process of investigation he may be interrogating so many people, interrogating the accused, inquiring the witnesses, and then sending the evidences to the concerned authorities, FSL to name one, and the doctor to name another, or the forensic medicine doctor, or the bomb disposal squad. So these materials will be sent to the concerned people, and he will be awaiting the reports from them, because analysis and generating the report is not one day's affair. It takes months, years maybe. So depending upon the workload that is there in the forensic science laboratories, it is going to take a lot of time for them to give the reports. So meanwhile, as and when the investigation is progressing, every day's report, every day's proceedings, every day development, he is going to write chronologically in what is known as a case diary. So for each case there is a separate case diary in which the day when it has started, and what is that he has done, what are all the places which he visited, who are all the people whom he has interrogated, and what is the outcome of that interrogation, what is the further progress in the investigation, as he talked about these things. These all after all these activities, some chronological record has to be there. So this is what is known as the CD or the case diary. So apart from case diary, the code also mandates that every station should also maintain what is known as a general case diary, because the police station, it should be in constant vigilance and security. So there may be terror attacks and all. So to guard the police station, there are guards. Guards will be kept on guard duty, and there will be shifts of duty and all. So all that the day's activity will not be written in the case diary, but then a separate diary will be kept for that, which is called a general diary. So what are the guard duties? Who are all the people on guard duty? And then whether arms have been, because a lot of arms will be there in the police station. So whether arms have been checked or not, and then whether somebody is on duty, or whether somebody were deputed for VIP duty or code duty. All these duties will be written. Who are all the people who are deputed on different duties, that will be written. And then the drill also, because they have to maintain that physique and then fitness, so there will be these things. So all the daily activities will not be written in case diary, but a separate diary called a general diary will be maintained. In that they will be writing all this. Now the statements will also be taken. So all the witnesses who are either eyewitnesses for the crime happening before their eyes, or somebody may be a witness for research, somebody may be witness for seizure, arrest and all. So for each activity in the investigation, we have to do the investigation in the presence of two respectable people of that locality, whom we call the witnesses. So witnesses are compulsory. They do not belong either to the victim side or the accused side, but then respectable people of that locality, we have to select such people who have good reputation and all, and then those who are willing and all. So we have to select those people, and then we have to request them, and then we have to request them to be witnesses for that particular activity. And in that particular incidents, we also try to take the signatures of these witnesses, and definitely if they are quoted in the charge sheet, as I said, they will be called as the witnesses. Now you must also have seen in the judgments that three categories of witnesses can be there. Now witnesses, as I said, can be produced from the side of the prosecution. In that case, they are called the prosecution witnesses, in short called as PW, P money prosecution, W money witnesses, prosecution witnesses. So accordingly they will be given numbers, PW1, PW2, PW3, like that. They will be, depending upon how many witnesses are there, accordingly serial numbers can be given to these witnesses. And similarly defense also, because defense will be represented by the accused will be represented by the defense lawyer or the advocate. Now he would also like to introduce his own witnesses. In that case they are called defense witnesses, in short DW. Now apart from these two categories of witnesses also, we do have a third category of witnesses. If the court is interested in bringing its own witnesses, in that case it is also allowed, and they are called court witnesses, in short that is CW. So like that we have PW, which are the witnesses on the side of the prosecution, and we have DW, who are called witnesses on the defense side. And accordingly, if the court itself is interested in producing its own witnesses, even that is allowed, and in short it is called CW. So PW, DW, CW is the nomenclature that is normally used in the court language. Now when the charge sheet is ready, and in charge sheet what exactly is going to write, now the first sentence that he has to write is, yes, this court will have the jurisdiction to try this case. That will be done, because if the defense can prove that it is not in the jurisdiction of the case, on that count there can be quashing of the FIR and all. So for that reason it is very, very important and mandatory to ensure that whether that particular court has the jurisdiction or not. So that has to be informed, and whether this court can do the trial of the case or not also has to be specified. So that also has to be specified. Now It simply says that this is the essence of the case. If it is a murder case, what are the ingredients of the case? Now, who are all the people who are examined so far? And what are the documents which he is going to produce? And who are all the people from the prosecution side he would like to introduce? All that will be written in the charge sheet. And apart from that, at the end of the charge sheet, they are going to include what is known as memorandum of evidence. So what do you understand by memorandum of evidence? It's a kind of a table which is going to give you the name of the witnesses who are going to be speaking on the side of the prosecution. So starting from eyewitnesses, starting from the complainant, and there will be eyewitnesses, there will be experts, because after all the evidences will be examined by the forensic science laboratory experts. So they will also have to be examined. So they are not called the witnesses, normal layman witnesses, they are called the expert witnesses. So what we need to understand is, apart from PW, though they are also called as the public, prosecution witnesses, but then they are a special kind of a witnesses because they have got a special knowledge, they have been trained specifically, and they have got a entirely different experience altogether on that particular subject. They are called expert witnesses. So they are also prosecution witnesses in a way, but then because of their special qualification, they are called expert witnesses. So like that, a list of all the witnesses on whom the prosecution is going to entirely base their arguments, the list of it will be given, and then the second column will speak in that memorandum of evidences that what is that PW1 is going to talk about. When we say PW1 is the complainant, what is that? What is his role? What is that he is going to speak in the court? Then comes the eyewitnesses. What is that he is going to speak? What is the area of focus that he is going to say something? So this will also be given. And what is the important point that we need to remember is, once these documents reach the respective jurisdictional magistrate, now it is for him. So meanwhile, before these things happen, these documents are going to be generated. Now, for the purpose of investigation, if somebody is arrested, now the moment he is arrested, within 24 hours of time, this arrested person has to be produced before the magistrate. Now, we know that investigation is not one day's job, it takes time. Now, you cannot just because the investigation is taking a lot of time, you cannot in the name of investigation detain the person for a very long period. Now, any police officer arresting or detaining the person in the station beyond 24 hours, then it becomes illegal detention. Now, under illegal detention, somebody on the side of the accused can also go for a writ of mandamus. So writ of mandamus, or for that matter habeas corpus, when the whereabouts of the accused are not known to the family, then they may say habeas corpus, my person is found missing, find him out and then hand him over to me. So that kind of a writ they can also go in for. And writ of mandamus, they are not doing their duty. So aisa karke they have unduly try to detain police because they have power. They have detained my person, and then let them release that person, produce that person, or let them do their duty properly. This kind of writs are given under constitution for a civilian. So they will say that it is an illegal detention. So you have to justify the detention. The police officer, just because some power is given to him, he cannot without understanding the limitation of his power, because every power will, it cannot be arbitrary. It will have some reason, it will have some basis, backing of the law. So accordingly, he has to justify whatever action that he is doing, whether it is arrest or whether seizure or whether search. So everything has got a justification, and he has to give reasonable grounds. Why is he thinking? What are the strong reasons based on which he is going for an arrest? What are the strong reasons for him to go for a seizure? All that you have to, though provisions are there, but then it also, the provision itself says that you should have the reasonable grounds, and you should write what those reasonable grounds are. Why you are not taking a warrant, why you are not not taking a search warrant. So for everything you have to write the reasons. Only when the reasons are convincing they may approve that, or otherwise they may say it's an illegal act, you are doing an act on which you have no power and all. So these kind of provisions are also there. Now once the person is arrested, as I said, and if the person says that I'll cooperate, now don't arrest me, then I'll give that assurance. If it is a bailable offense and all, I am going to give the bail, the undertake the bail and then pay the amount whatever it is there. Or if the situation warrants that I have to produce some sureties, I don't mind producing the sureties and all, he has to give that undertaking. Now once under this 154 section to 173 will be entirely your investigation and all. I mean cognizable case है तो क्या करना है, non cognizable में क्या करना है, कैसा करना है, all that will be there in the CRPC right from section 154 to 173. 173 speaks about your final report and then how that final report has to be taken, and 190 and all will speak about your the cognizance that will be taken by the magistrate, what will be the fate of the the complaint, and then when he can take, and what are the three options to him and all is about the complaint. And from 200 onwards it will, the section will be that. And meanwhile we have that in the 154 we say the first information report and all will be covered. Now not only that, some whenever we talk about some sections or some procedures, it will be good practice, at least the law student should remember that in landmark cases will be there, some good citations will be there, if not the entire citation. So as at least student of a law, what is expected of you is just mention the name of that case. Like for example, Lalita Kumari case, I keep on telling that case because that's a very important landmark case whenever somebody wants to talk about the 154. Now what 154 says is, as a mandate, when a cognizable offense is reported, or when the facts of the case reveal that a cognizable offense has taken place, now it is without application of the brain. You have to register the case, that's it. You need not use your prudence or your imagination and then try to go on doing some preliminary inquiry. Now the Lalita Kumari case says that preliminary inquiry as a matter of fact, as a matter of routine, need not be done in all cases because it's again a waste of time. What they say is, but very important cases, when the cases pertain to bribery, corruption, or when the matters pertain to the marriage, like divorce or something related to family affairs and all, then divorce, marriage and all, when marriage itself is a dispute marriage or fraudulent marriage. So matters relating to marriage, corruption or the bribery and all such type of cases, they said no, the registration can be little delayed because you need to do what is known as a preliminary inquiry. So preliminary inquiry will not happen in a day. So some 15 days time is the maximum time. They said you can make a preliminary inquiry, then go for the registration of the case. So for that reason, for the first time in Lalita Kumari case, whether there should be a preliminary inquiry or we can do away with the preliminary inquiry, is it that in every case we have to do away with preliminary inquiry, or are there some exceptions to this where you are allowed to do some preliminary inquiry, ensure that the case is made out, only then register the case. So this has become a very sensational case, and whenever some new concept is coming up, then we call such cases as landmark cases. And as far as FIR is concerned, then you have to definitely remember this case, which is called Lalita Kumari case. So Lalita Kumari case is important because FIR speaks about whether preliminary inquiry should be there or not, and if at all a preliminary inquiry is going to be there, then what cases the preliminary inquiry should be there. And not only that, it also says that after preliminary inquiry how many days it should be there and what exactly should be done after that is all given in the Lalita Kumari case. Now after 154, I said there are witnesses, and from each witnesses also we have to take what is known as the statements. Now the statements are taken under the section 161. 161 simply says that whenever somebody is familiar with the facts and circumstances and some information about the case, they are asked, and they will be, and except in some cases where aged people are involved, a person who is below 16 years and all, or infirmity, or if a lady is there, or if it is a case of rape, except that cases, they will be, in such cases the police officer himself has to go to their residence and take the 161 statement. Or otherwise, in all other situations, it is mandatory that these people should cooperate, because for the purpose of investigation he is struggling very hard to get the witnesses and all, and if you know that you are the witness and then deliberately you are not cooperating, then you are liable for punishment and all. So he has got that power of summoning anybody or calling anybody and then say that you seem to know or you seem to be familiar with some facts and circumstances of the case. You please come and then say whatever you have seen or whatever you have heard and all, and then please reduce it to writing. So only provision, only thing when we take 161, the very important point that is associated with this is that these statements should never be compelled by the witness to be signed. These statements, otherwise all statements, whoever is the maker, they have to sign. But then the exception is 161 statement, though it is the version given by the witnesses, they should never be compelled to sign it. But nevertheless, it will be prepared by the investigating officer, and so where is the guarantee that whatever the witness said is exactly reduced to writing? So to ensure that also the contents of what is being written by the investigating officer, which is a oral version of the witnesses, will be read over. It will be read over to him, and it will also be ascertained whether what is written, is it exactly what you said. Then the option will be given to him, and only when they say yes, it is found to be exactly what we said, so then the IO himself only puts the signature. The witnesses will never put a signature. Now this is what is the purpose when they are not going to sign and all. What is the purpose? Why are they being taken? Now at the time of trial, this will be used as previous statements, because these statements will be made earlier to the trial. So trial will happen at a very late time, at the later part of the time. So hence, for that reason, it will be taken for 2-3 purposes. One is to refresh his memory. That means for trial to happen, it takes years together. So by that time, the accused may be, because he is involved, he may remember each and every detail. But that witnesses may not remember all that, isn't it? So for that reason, so whatever statement that is made, this statement will be made available in the court for him to refresh his memory. He can read that particular 160, because court will also be given these copies. So the court or request court will give that statement that is made by him, and he will go through that, and whatever he said, because they will be subjected to cross-examination also. Not only the chief examination, but cross-examination will also be there for them in the trial. So for that reason, if he has to refresh his memory, he will be given that 161 statement, which he has never signed. Now, what is the purpose of that? As I said, refresh memory. Now, suppose there is a controversy. Now, what he has said earlier to the police and what now he is uttering, because he will be summoned, he is quoted as a witness of the prosecution. Definitely someone will go to him, he will appear on that particular day in the court, and then he is going to undergo what is known as chief examination, cross-examination and re-examination. Maybe in the re-examination, whatever he told, whatever he has given a version to the police, when he comes to the court, he is giving entirely different version. He is giving an entirely different version. Then in that case, the advocate who is doing the cross-examination, he can use it for his for his own interest, in his own favor rather. So how is it possible? Now in the cross-examination also he can check it, or he can also use it for prosecution will use it for corroboration, whereas defense will use it for the purpose of contradiction. Now whenever contradiction is there, So what he is deposing now and what he has uttered before the police officer. So whatever he has uttered before the police officer constitute what is known as the previous statement, because these statements were made earlier to the trial, hence they are called previous statements. So hence 161 is also one such previous statement which is made before the police. Now if suppose in the process of cross-examination by chance if that witness has said something else in the something else before the police, and now that what he said is quite in contrast, what he told to police, now he is not saying that, he is saying something which is quite contradictory to what he said to the police in the court. Now it is what is known as contradiction, and whenever there is a contradiction in the statement, that will be highlighted and that will be marked and that will go against the, so this is only to cross the defense is going to use this particular contradiction or omission at times. So he must have mentioned something in the 161 and he suddenly omits in his oral deposition. So in that case also it is called omission. So all contradictions, all omissions are matters for cross-examination, and they will be richly used by the defense to make a very strong case in favor of his client, that is the accused. Now the purpose of 161 is either to refresh memory when the witness is going to refer for refreshing his memory, or it can be used by the defense for the purpose of contradiction and also for the omission, and thereby prove that, see, this person is unreliable, he says something before the police and something else before the court, so he is unreliable, he is interested witness, or this witness is biased, or his trustworthiness can be questioned. So like that in the cross-examination, the 161 statements are going to be used. But nevertheless, if somebody knows some facts of the case and all, there is no other option for the IO than to take the 161 statement. As far as the IO is concerned, this is for this purpose. And as far as the court is concerned or the defense is concerned, this will be for some other purpose. So like that 161 is going to act as a corroboration, or it is for defense it's going to act as a what you call the contradiction. Now when this is going on, now if in the process of understanding the witnesses and all, when they give the summons to them while taking 161 statements, at one point of time the IO feels that this particular witness is very crucial witness, very important witness for us, and if he goes back what he is saying now, it will be very fatal to the case. So in order to bind him over, what they do is, very important witnesses, instead of they reducing it to writing, they will take him to the nearest jurisdictional magistrate, and then before the magistrate they will produce him, and it will be the job of the magistrate to reduce whatever he is saying to writing. And then on oath, whenever we say magistrate, in case of investigating officer, there will not be any oath, but when that witness is taken to the magistrate, then definitely the magistrate will have to exercise abundant caution. Now what are the cautions and all is very clearly given under 164. So when it is only by the police, if they are taking statements of the witnesses, then that is covered under 161. So 161 documents are never signed by the accused. So in case of 164, where I said a particular witness deposition is very important and he should not go back what he said earlier. So to make him bind over, then I said under 164, which has more reliance and more reliability, so the particular witness will be taken there before the magistrate, and magistrate is going to give him enough caution, because it is his duty to tell the witnesses that whatever now you are uttering, you are making these statements voluntarily. This is very important. So make the witness or the accused understand that whatever statements he is making, they are not made under inducement, they are not made under coercion, or they are not made under pressure. Though this particular point has to be made very, very clear to the accused or the witnesses who are making these kind of statements. And definitely there will be oath, and under oath, in presence of magistrate, if they are doing, the objective of this is that he will not go back because of some sanctity, because of some authority he is giving. So normally the presumption is that he will not go back from what he said to the magistrate. So, and then because such type of sanctity is attached to 164, so there are guidelines which mandate that the magistrate definitely should caution. Magistrate should caution that person, the witness, saying that, see, you are making these statements. There is no guarantee that these statements will not be used against. Definitely they will be used against you. So think about giving the statement. Just because the IO has brought you to my presence, there is no compulsion that you should make. If you want to remain silent, you can remain. If you want to withdraw, that I don't want to give any confession before the magistrate, because 164 statements talk about both statements and confession also. But confession will not have the same kind of a confession as we talk about in admissions and confessions. But nevertheless, so this can be strongly used as a corroboration, though 161 can also be used as corroboration. But compared to 161, 164, because of the special situation, that is, one, he is making before the magistrate; second, that he is making this statement or confession on oath. So both these things are there, except cross-examination, rest of the things are there. So it will have more reliability when compared to 161 statements. So 164 statements are also there. Now there is 167, which is also very important. Now the investigation is not happening within 24 hours. So what is the option? So can he, should the IO give up the case and then say, within 24 hours I am not able to complete the investigation, let me drop? So there are provisions again in the law which says, if a particular case cannot be done, investigation cannot be done within 24 hours, then immediately produce the accused person before the nearest magistrate, and with all the documents, FIR and whatever case report that has so far been done, that will also be submitted to the magistrate, and then with a request to the magistrate, please remand him. Remand ka matlab, you give him back to me, so that there is still some investigation left over. Now all cases only 15 days extension can be given, and if he is an executive magistrate, so when there is no judicial magistrate available, the IO can also approach the executive magistrate, but his power of further increasing the period of remand will be limited, and it will be restricted to only 7 days, unlike a judicial magistrate. So judicial magistrate, for every 15 days he can increase the period of remand. So for remand also there should be justification, not just as a matter of right, the IO can ask for remand. Now whenever he requests for a remand report, a specific remand report, which is something very similar to see this CD part 1 and all, every detailed thing. So why he wants a remand of that person, what are all the things to be completed, whether investigation is pending still, interrogation is pending, or FSL reports are away, are not yet reached, or the medical examination is not yet over, or things like that. The genuine reasons, reasonable things, if they are mentioned, then the magistrate is definitely going to give the remand. So the remand can be two types. One is the police remand, and then or police custody, or the magisterial custody, or it is called the judicial custody. So judicial custody, depending upon whether the IO wants further investigation to be done, he wants him to be given back to police, then in such case we call police custody or police remand. And for every remand also there should be justification why he wants a remand of that person. There is a very detailed remand report with all furnishing documents and all, and when the court is convinced, yes, there is a considerable portion of the investigation which is pending, so accordingly they may grant the remand. So that is also about 167. For how many days remand can be there, when executive magistrate is involved, what is his power and all, is all there in 167. Now when once the challan is ready, 173 is ready, now it will be in the magistrate court. Now there is also terms like summons case and then warrant case. So summons case are those cases in which summons will be issued, and warrant case are those cases in which warrant is here. So as I said, summon can be served, and whereas warrant is directed. So whenever court comes into picture, we use the word directed. Whenever police station is involved, we will all only call it as a serving the summons, and warrants will be directed. Now warrants cannot be given by the police. So that is, what is that you can understand now, like cognizable, non-cognizable, bailable and non-bailable, summon and warrant, you should also discriminate. So whenever the offense is of serious nature, we use the term warrant, and when the offense committed by the accused is not that serious, then we use the word summons. Now, as a matter of fact, summons will be served, we know that, to the witnesses, and apart from the witness, summons can also be served to the accused. Now, the purpose of summon I have already told, but only thing is, now summons, for some reasons, there are again sections which deal with summon, what should be the format of the summon, who has to sign the summon, what particular should be there in the summons, and for summons also there is a format which is given again in schedule 2, what should be the format, who has to sign and whom it will be served, what is the date, whether date is mentioned or not, all that will be there. For some reason the person is not available. Now what is the other option? So the sections deal with what are all the options. Now when he is not there, adult, at least ensure that some adult male person is there in the house, and you give that person and then obtain an acknowledgement at the back of the summon, and then that means it is the summon is served. In that case it is deemed that the summon is served. So for witnesses and all, it will be by the post also we can do it. Now what if the government employee is involved? Now you cannot, there is an option of going on leave or going on training and all. There are so many options for the government employee. So it is not necessary that you should serve the summons to the individual only. It can also be served to the HOD, that is head of the department will be there. And once you obtain the signature of the HOD, it is HOD's duty, responsibility to ensure that the summon is served to the, given to the proper individual only. Now summons are not serving the purpose, so he is avoiding summons and all. Next will be warrants and all. Even for warrants also he is not listening, and then there are options again. You can forfeit his properties, and then you can also declare him as a proclaimed offender, and all. There are options. So in case if he is disobeying summons, in case if he is disobeying warrants, then forfeiture, his properties can be sold out. There can be notices, and the notices will be put on conspicuous places and all. Somebody at least listening that you are wanted in this case and the summons are being served, you are not obliging the summons and all. So like that there are several ways to do it, one after the other. All the options have to be exercised, and there can be forfeiture also, and later on he can be declared as a proclaimed offender, and somebody being proclaimed as an proclaimed offender and all is a very serious matter, of course. And then these are all the options. Now as I said, summons case are not that very serious when compared to warrant cases. And how will we decide what is the punishment? That is 7 years to 10 years and above serious cases, and a case more than 2 years, 2 years and above is a very serious case, below 2 years is not that serious. So accordingly summon cases, warrant cases will also be there, and accordingly summon cases are to be, depending upon that we have to again, trial process also is accordingly classified. Now we have trials which are summarily can be done, summary trials they are called. Trial in petty case, for example, you have not purchased the ticket, and then there is a magistrate sitting in the bus, and then he say, you please pay the penalty, you have violated this, please pay the penalty, and that is a very petty case. So for petty case, the court need not waste their resources, they need not waste their manpower and then time. So they said petty offences can be summarily tried. So petty offences altogether, not summarily also, they can be decided then and there only, without any procedure, formal procedure of the court. They can be decided then and there only. And there are little serious than petty offences are summary type of trials. they can be decided in summary trials. And then comes the summary, after summary comes the summon cases. So summon cases, I told you 7 years and 7 years and above will be warrant cases, and below 2 years normally will be called a summon case. So for summon case also the procedure need not be that elaborate, but when it comes to warrant cases, then it's a very serious offense, because 7 to 10 years, above 2 years, such cases are involved. Then there should be very elaborate procedure, because after all you are putting somebody's life and liberty at stake. So accused should be given fair trial and all. For that reason, the procedure that is involved in the trial has to be very, very elaborate. So accordingly, the trials will also be classified. So what is the classification? The trial of petty cases, the trial of summary cases, the trial of summons case, the trial of warrant case. So accordingly, 4-5 categories of trials are also there. Now, before the trial process commences, there are some pre-trial kind of procedures that are also involved. Now, what are all the pre-trial procedures? There is a very important concept called framing of charges. That means when you do not specify, when you do not enlighten the accused that these are all the charges with which you are charged. Otherwise, how does he know what are all the charges that are levied against me, and then what kind of defense argument I should prepare with, whether it is the accused himself preparing or whether he takes the help of some pleader or some advocate. But for him to understand what are all the charges in the first place, whether murder or murder with some other thing, or what are the offenses under which he is charged, that should be made very clear to him. Now that can happen only when they hear both the sides. Both the sides, the argument they have to hear. Who has to hear? The court has to primarily hear what are the arguments on the side of the prosecution and what are all the arguments on the side of the witnesses, on the side of the defense, who are all the prosecution witnesses, who are all the defense witnesses. After hearing both the sides and after going through all documents, relevant documents introduced by both the prosecution and defense, now they come to some conclusion. Yes, prima facie, it can be, the person can be charged, and then he is going to make what is known as a framing of charges. So framing of charges is entirely by the presiding officer, and he takes the help of both prosecution and defense while framing the charges. And then after the charges also, framing charges also, there is a format for that, in which what is the name of the offense, under which section is going to be charged and all, and for how long the punishment is going to be there and all. And there will be what is known as the examination of the accused. So primarily the duty of the presiding officer or the judge is to make him understand that these are all the acquisitions which are made, and these are all the, after the argument of the both the parties, so these are the charges levied against you. So you want to plead guilty for that, or you want a trial to happen? Now definitely nobody, no fool, no accused will say that no, I am guilty of the offences. Maybe in some very rare cases they may do that, but otherwise it is the accused will always say that no, I am not going to plead guilty for that, rather I want to be tried, I want a full trial to go on. So on the option, then the again the further, so from there onwards the trial process will start only, not just because people are going to court. We should not say that trial is happening. So trial, the beginning of the trial is only when the accused is made very clear about the charges which are being framed against him. So who is going to frame the charges? It is not the police. It is only formal acquisition by the police. So when it comes to court, it is the pakka kind of a framing of charges by the presiding officer. By listening to both the parties, he is going to he is going to frame the charges, and he is going to read out those charges to him, and then finally he will ask. So before that, after going to argument, if he feels there is no case made out, actually there is no case made out, no ingredients are going to be fulfilled, then the presiding officer has no hesitation in discharging the person. Look, complete discharge of the person is different from acquittal. Discharge can happen before the trial. Please understand the difference between the words discharge and then the acquittal. Acquittal is after the entire trial process based on arguments, then the court will decide whether he should be punished or whether he should not be punished. So that is at the end of the trial. But then what is discharge is something, no, even before the trial also, after listening both the parties, if at any point of time, if the judge feels
Sorry
that,
to interrupt.
yes,
Ma'am, I had a doubt.
yes,
I just want to know, ma'am, at the time of framing of the charge and taking the cognizance,
what is it? You can be little louder.
ma'am, at the time of framing the charge and taking the cognizance.
No. Taking cognizance is something different. Don't club these two.
No. Okay, ma'am.
See, cognizance is something different. It will happen even before that. Cognizance is, when a private complaint goes to the magistrate, as I said, they can either go to the police. A private person has two options. Either go to the police station, lodge his complaint. That is one thing. So, for some reasons, police may not entertain. Or the second option is go to the superior. Even that is, he is also not entertaining. So the third option for the private person is to go to the magistrate straight away with his complaint. If he has some witnesses, go to him. So if he is, by reading that complaint, by examining the witnesses, then if the magistrate feels, then that is called taking cognizance of the case. That is called cognizance.
Okay, ma'am. Ma'am, my another doubt was at the time of...
Now, you want a difference between cognizance and what is it?
No, ma'am. At the time of framing the charge and what the cognizance taken, does the accused have the right to produce any material or any document, to the court to examine?
No, he will do that. Before that, I said, before framing the charges, there is another process before that. What is that? The court has to listen. Otherwise, court is also ignorant. In absence of any information, they are also ignorant. So for the first time, they will listen both the parties because witnesses are there on both the sides. I said witnesses can be produced from the defense side also. They are called DW. Our court may feel that there is a need for the court to introduce its own witnesses, court witnesses, CW. So they will examine all these people, So examine them and then they'll try to collect the information. And based on that, the court will frame, the judge will frame the charges, For framing charges, he may take the help of prosecutor also and then the defense fellow also. Both, three of them, they sit together and then frame charges. Once a document is made ready in the form of a framing of charges, then accused should also know, isn't it? So that's the reason why accused will also be made available. And then there is another very important section called 313, under which the examination for the first time by the magistrate will also happen. The magistrate will have the privilege of examining the accused. And then he says, see, mister, there is a framing of charges against you. And these charges are framed against you. And this is the version of the prosecution. They have these kind of evidences against you. Now tell me whether trial should go on. What is that? Are you going to plead guilty for that, or you want a trial to be run for that? So accordingly, the option is thrown to him. Now, in case if you, as a good boy and all, if you want to, kubul kar rahe aapka jurum jo bhi hai, you are confessing. You said no, I am guilty. So there is no further need for the magistrate to do it. Or if the magistrate is so strict and then he wants to follow the principles of natural justice and all, not based on the confession alone, he may further proceed and conduct the trial. That is a different story. But then if he says, no, I am not guilty, I want a further trial to happen. So in that case also the trial process has to take place, then your chief examination, cross-examination, re-examination, all that, and finally based on the arguments, then he may say at the end, prosecution failed or prosecution is successful, they can prove the case beyond reasonable doubt, and all that will be there as a part of a judgment. I think I am clear? Mr. Patel?
Yes, ma'am. Yes, ma'am.
So he can also produce, nothing prevents the accused to produce his own witnesses if he has got some, or if he has got alibi, or if he feels normally the defense on the part of the accused is, only thing, because normally in adversarial system, the burden will be on the prosecution. As per the Evidence Act, burden of proof, if you see that particular chapter, normally the burden will be on the prosecution, because they are the ones who are approaching the court with a request. What is the request? So there is a case happened and these are the facts, and you please restore our rights. Because whosoever is the party who is asking for the restoration of their right are the ones on whom the burden will lie, burden to prove. So it is normally always the burden is on the prosecution, but burden at times shifts. Burden at times or onus at times shifts to the defense. What is that? Now, accused always will also defend. What are his points of defense? Once he says the defenses, the general exceptions. He will say that I am intoxicated, I am insane, this and that. There are general exceptions, When we talk about IPC, I'll deal in more detail what are those general exceptions. So he would like to present his case that as if it is coming under the general exception. That is one thing. Or else he may say that some alibi and all, and during that particular time, I am not there, and it is physically impossible for me to come and be there present on that particular day to be involved in a crime. So like that, he is going to bring some exceptions or quote his case under some exceptions. So in that case, the burden shifts. That means if he says I am not there, the burden will be on the accused now instead of on the prosecution. The burden will be on the accused to prove that on that particular day, on that particular date, he is away from, and he has to produce some evidence, some ticket, some kind of evidence to show that he is really not there. So the owner shifts. Otherwise, it's normally on the prosecution. So burden of proof and all will be chapters under the Evidence Act. I think it's quite clear.
Yes, ma'am.
So accused also will have his defense. Now to get his defense points, where is he getting? He can bring his own defense witnesses, or else in the cross examination, based on what witnesses are giving in the chief examination, those points will be very strong points for the defense. If suppose the witness, he can prove that the witness is untrustworthy, his credibility can be impeached. How can he impeach the credibility? He'll put such questions whereby he wants to prove. In several occasions, this man has taken bribe, this expert has taken bribe, and then he always gives reports in favor of that. So he has to establish not mere acquisition, but then he has to establish that earlier occasions in some particular case, that case details also he has to give. So in such cases, he is known to give reports under pressure, or his character is such that he is always a kind of a wrong witness. So like that, he has to prove. That cross-examination is very, very crucial. So in that, they are going to shatter the confidence of the witness. How? Not by rebuking or not by scolding, but by very logical and very intelligent way of cross-examination. He is going to impeach the credibility of the accused. And then for that, your 161 statements or previous statements, they are going to be very strong weapons in the hands of the cross-examination. Now the framing of charges is done, and that will be read over to the accused, and then after knowing that he wants a trial, he doesn't want to confess his guilt, and also trial proceedings go on, and then both the sides of the arguments, their evidences will be introduced, they will be marked, there will be arguments and then the counter arguments, and after listening both the things and after scrutiny of all the documents which are introduced in favor of prosecution, in favor of the accused, now it is for the judge to marshal all the evidences, and then after marshalling all the evidences, and then he will only say that these are all the charges. If it is a murder case, these are the ingredients, whether prosecution was successful in proving all the ingredients or not. If they have fulfilled, then he'll write successfully could prove, and in case if there is not much evidence, or the evidence is not that supportive, then he will write again the prosecution failed utterly in establishing the case beyond reasonable doubt. Hence, the benefit will go to the accused, and hence he is going to be acquitted. So that kind of a judgment will also be there, and judgment can be either in either in acquittal, which will be in favor of the accused, and it can be in favor of the prosecution. So either way, both the parties will have the privilege of appealing that, because that's not the end of the story. There is an appellate court, and then the aggrieved party definitely will approach the appellate court, and then they have to exhaust all the means, and then thing. But only thing is, the powers of punishment, as I said, will also differ. There is a hierarchy of the courts and all, and the session courts will have some powers on par with the high court, wherein they can award the death punishment, but only power that is there with session is they can pass the order, but then confirmation has to come from the high court. That's the only thing. Otherwise, the powers of they also have the power of awarding a death penalty, but then that has to be confirmed by the high court. So this is the trial process, and there are different trial processes depending upon it's a case of summons or it's a case of warrant. Accordingly, that trial process will commence, and then some trial process require elaborate framing of charges. So some trials, they do not require, it can be only a formal kind of a framing of charges. It need not be that elaborate, and based on that we said summary trial, summon trial, petty case trial, and then warrant trials, and then the trial which is conducted exclusively by the sessions and all. So like that we have different trial processes, and then after that the aggrieved party, if they are not happy, then again these appeals and then revisions, these procedures will be there, and it's a systematic way. I mean, the entire process of criminal procedure is based on the principle that accused should be given fair trial. There should be fair investigation. Not only at the end it should be fair, but throughout the process, right from investigation till the case reaches the trial phase, there should be complete transparency. There should be complete fair kind of a judgment, fair kind of a trial, and fair kind of investigation should be there. And accused he also has a lot of rights, and then we should ensure that, because human rights way back, and then they have given lot of guidelines, and then any violation of arrest will be viewed very serious, and then illegal detention, illegal arrest, and then all that. The Constitution has given us the Constitution rights. When fundamental rights are violated, the courts are coming to picture, the High Court and then Supreme Court. Then you can have the provision of writs and all. So writs, even citizens, they can file directly under the apex courts. So these provisions are there, and one such provision is illegal detention. So it is a very serious matter, and when somebody is in the custody and they are not producing, and whereabouts are not known, and all the relatives are panic, what has happened to our kith and kin, in that case they have provisions like habeas corpus and writ of mandamus, because they have taken him in the name of interrogation, and from that day onwards he is found missing, his whereabouts are not known. But then for relatives, they want the presence of the person, produce the body, produce the person. That means habeas corpus. And then you are failing your duty, you are not doing the investigation properly, unduly you have detained some person. Then in that case, you please do your duty, do the mandatory duty, which is called the writ of mandamus. So like that, there are writs which are there. So the citizens can very well approach the appellate courts, and then go for writs and all, ensure that their rights are being properly protected. So this is in short the overview of the entire criminal proceedings, and maybe in classes forthcoming we can have more details of each thing, like session, difference between session, warrant, what is trial, what is inquiry, what is investigation, and all more details we can have as per the syllabus. This is all overview, because unless until you understand the overview of the entire procedure of how the crime happens, how it will be investigated, and how finally the trial goes on, and how judgment is pronounced and all, unless you have an overview of the entire process, it will be very difficult for you to just study in piecemeal and try to understand and then be happy that we have mastered CRPC. It's not like that. The CRPC, IPC things for a law student will be at least 3 to 5 years. So if you want to just have a glimpse of that also, it takes a lot of time. So just to make things clear, I thought overview of the entire thing, both CRPC, IPC. I will also come to Evidence Act some of the class, but as of now for today, this is in 2 classes. I think I have tried to cover the maximum aspects and including your syllabus, but for the examination point of view, to write in clear sentences and all, perhaps we'll have some PowerPoints made, and I'll also try to share that PowerPoints so that it becomes easy for you for the exam. And I need not remind you about tomorrow's and day after's examination. I think the procedure, how you have to download the app and then how to go ahead with answering, how to post that answer in the app and all, I think Meghna will be the right person to tell you all that. I think by now she must have told you, or else otherwise in the class, today's class, after my class, she is going to tell you. But only thing is, she has shared her link, because the other two, there are 2 streams as of now, no? The other stream can also have an understanding of what that app is, how you are going to. So I request the remaining people also be there in Meghna's class, because some serious instruction is going to be given with regard to the tomorrow's exam. So I request both the streams to be there for the next class also. The link, I think she has already shared to all of you. Had she shared? Did she share that link?
Link regarding the app?
No, link, the instruction, what is that app that you have to download, how to go about it for tomorrow's exam. Tomorrow and day after you have exams, isn't it? Are you aware of that?
Yes.
Yes, ma'am.
Online exam you will be there. So what is that online, how to go about it, what is the platform and all, you should have some fair idea, isn't it? So what she said is, so anyway her class will be there for one stream, crime scene management stream, we have class. But then the request is that let the other stream also be there in her class. She has already shared the link for her class. So both the streams be there in her class, so that whatever instruction she wants to give for the online examination, that will be valid for both the batches. So soon after this class, you please link up to that, because you have a second class also on the paper 2, crime scene people, isn't it? So let the document people also be there for the online exam. Is it okay?
Okay, ma'am.
For now we can leave the meeting. It's almost only 10 minutes left. We can just meet in the next class, Monday, after the exam.
Okay, ma'am.
Anyway, all the best for the exam.
Thank you, ma'am.
Prepare well and write well.